As a Seattle-based attorney who's litigated a wide variety of domestic violence protection orders throughout the Puget Sound region, both prosecuting and defending them, I've come to some generalities about them that are worth sharing and that are of interest, I think, to anybody that's involved in this kind of litigation. Domestic violence protection orders, or civil domestic violence protection orders, are part of the Domestic Violence Prevention Act. And I believe that the origins of the concept have to do with that there is behavior in relationships, be it intimate or be it familial or just be it living in as a household, that are unacceptable, but for whatever reason don't rise to the level of criminal prosecution. So I like to think of it a gray area of behavior where civility ends but the behavior must stop, but it doesn't rise to criminal. And the way the Domestic Violence Prevention Act, or Domestic Violence Protection Orders, defines that gray area is that it's behavior that's either intending to inflict the fear of or actually is physical harm to somebody else, bodily harm, assault, or sexual assault. Domestic violence protection orders also include behavior that's called stalking. What is the legal definition of stalking? It's a little different, I think, than what a lot of people think. It's when you harass or repeatedly follow another person and you cause that person to fear that the stalker intends to cause them harm or cause someone else harm or intends to harm their property or cause harm to somebody else's property. And that fear is one that a reasonable person would have under the same set of circumstances that the filing party is in. And the stalking party must intend or should know that they are causing the other person to feel afraid, intimidated, or harassed. And I like the should know because some people just simply aren't aware that, or claim they're not aware, that their behavior is causing someone else to be afraid, intimidated, harassed. And that's absurd in some cases. And it's amazing how people don't perceive themselves honestly. Domestic violence protection orders are pretty easy to file. There's a standard set of forms throughout the state of Washington, and as a policy, we file always in the Superior Court, where the filing party either presently resides or used to reside if they're fleeing a situation of domestic violence. And what that allows us to do is to hide the present address of where the person lives if that's necessary. What will happen when you file one of these petitions is that you'll have a hearing that day or the next day, and a judge will look at your petition and make a decision of whether to issue one of three things. A temporary protection order because the judge thinks, you know what, this behavior is so scary and so eminent that we need to stop it right away. I want to put an order in that says stop right away, and I'm going to set a hearing in 14 days where both parties can argue about it. I'm going to set a hearing in 14 days for both parties to argue about it because I don't feel like there's an immediate threat. Or the judge will deny the order and say that doesn't rise to the level of domestic violence. Whether you have a temporary order, if you get an order, that order needs to be served on the other party to become effective. And so as a policy, we always use police officers to serve on the other party. And so that party will get notice of that hearing date that was set 14 days later. Sometimes that notice is at the last minute. They get served 2 days before the hearing. And you do recognize that these are still civil hearings, and people have a right to properly prepare or defend their case. And so if something like this happens last minute, generally speaking, we have always had success asking the court for a bit more time to allow us to prepare the case. If you're going to file a domestic violence protection order, and it's a legitimate issue, as a policy, we always require our clients to contact a victims advocacy group and form a safety plan. New Beginnings is one that comes to mind. But there are many women's help groups throughout the Puget Sound region and the Northwest region that assist women who are involved in a relationship where there is a pattern of control and dominance that is driven with physical, bodily assaultive, sexually assaultive, economically assaultive behavior that they are trying to get out of. And I have gone to some of these meetings run by Dawn and New Beginnings, and what I am most impressed about is how comprehensive these safety plans are. Until you call one of these agencies, you don't know. And there is a way out of these situations, but it requires some forethought when you're dealing with somebody who's potentially scary or is scary. In terms of these being falsely filed, or the allegations being false, commonly we most see them in relationships that are coming apart because the remedies that domestic violence protection orders give to a judge or commissioner are very broad and include such things as control of a car, control of a house, primary care or parenting of children. And so domestic violence treatment programs, they can order it. They can order, the list goes on. You should look at our website or look at it. It references the code sections and outlines what the potential remedies are. But what we see people doing is filing these protection orders to get primary control of a house or residence, get primary control of children, get primary control of pet, get primary control of vehicle, when they really weren't afraid in the way that the domestic violence protection order defines fear, but they want their control, or they want dominance in a divorce action, or they want to set precedent that they're a victim and play that role. And these are difficult cases to litigate, but certainly winnable. It all boils down to facts, paying attention to detail, and talking with your lawyer extensively and collecting as much evidence as possible to prove that the accusations are either exaggerated or non-existent or are part of a behavior that's been ongoing. If you're involved in a domestic violence protection order, I highly recommend reading the revised Code of Washington, the RCWs, RCW 26.50, and all of the subchapter of that. It's quite interesting to read, and will lay out how these cases are handled, and at least they'll give you the fundamental rules that you need to abide by in one of these matters.